Yeah, I understand he posted bail.
He did, and we're just going to be, I don't know if dates were set on his matter.
Not yet.
Well, in that case, I have provided his attorney's number to him through Ms. Capone, so he should be getting in contact with Ms. Simmons. We are just asking to strike dates.
All right, is Mr. Ruelas here?
He was, but he had to appear for Superior Court.
Oh, so he had another hearing. Okay. Yeah. All right. Well, we'll send him notice for new dates.
Thank you, Your Honor.
Yeah. Okay. Well, that ought to work. All right, and Ms. Capone, let you start.
Thank you, Your Honor. This is Mr. Villaruz, numbers 16 and 17 on the calendar. I believe I just learned that the court was not able to secure a Tagalog interpreter.
Okay. Does Mr. Villaruz need a Tagalog interpreter?
Yes, Your Honor.
Okay. Gonna need to get one. All right, let's see. It's mandatory. Oh, this is a today case. Okay, then you just put this on the calendar for tomorrow. All right, we'll just reset this to tomorrow, May 22nd at 1:30, which is within the appearance timeframes under the court rule anyway.
Thank you.
Right.
And Your Honor, I know there was another interpreter matter scheduled. I don't know if that interpreter is on, if we want to address that.
Yes.
Mr. Yu, he is number, sorry.
21.
Number 21 on the calendar. He's choosing not to come to court today. It was my intention, and I'm still working on it right now, but my intention to file a 1077. But Mr. Yu will not be joining us today.
All right. In that case, then, Mr. Wan, I know you were booked to come in to provide interpretation services for Mr. Wu, but you just heard what his attorney said, that he is declining to come to court today. So I appreciate that you came, but we won't be needing your services today. So you are excused, sir.
Thank you.
All right. And before we go on to any other proceedings in Mr. Wu's case, I don't think we necessarily need competency proceedings because we already know that he's not competent, and we already know that the Superior Court has ordered competency restoration services, and that he's been in this status for well over a year with some charges that are pending in the Superior Court. So I don't think it makes sense to duplicate that set of procedures in the district court and involve additional personnel, including attorneys. So I mean, Mr. Fortune, I'm going to kind of point at you a little bit here, your office, but you're here as a representative of your office. You've got Class A's pending in Superior Court and have for a long time. This case arose because a police officer wrote a citation. Now, I don't know how that fits into your office's prosecution plan, or if it does, but I'm going to ask you to take a look at that and let us know what you'd like to do with Mr. Wu's case.
At this time, the state's making no motion to dismiss the charge without prejudice, Your Honor.
All right, I think that makes sense. And then we won't need to calendar any additional hearings on this in district court. Okay, now Ms. Capone, who have you got with you?
Your Honor, present with me is Mr. Perez, number 12 on the calendar.
Okay, Jimmy Perez. Good afternoon, sir.
Good afternoon.
Mr. Perez, today you're here in court for your first court hearing and arraignment on a charge of unlawful possession of controlled substance alleged to have occurred on May 20th. All right. Ms. Capone.
Thank you, Your Honor. I advise Mr. Perez of his rights, and I believe he understands them. Not contesting probable cause for today's purposes, asking the court to enter a plea of not guilty and to appoint counsel for my office going forward. There was some discussion with Mr. Fortunato's office about a lead referral, but Mr. Perez indicated he's not interested at this time.
Okay. All right, Mr. Perez, I'll enter your plea of not guilty to the charge of unlawful possession of a controlled substance. And do you need the public defender to represent you in this case?
Yes, I do.
I'll appoint their office for you. All right, and Mr. Fortunato, what's the state's position on the conditions?
Your Honor, I will note that Mr. Perez has 2 active warrants, one out of King County Superior Court and one out of Issaquah Municipal. However, there is no objection to a PR release, but with those active warrants, I'm going to be asking that Mr. Perez update any contact information to be provided his next court date. I would also ask for standard conditions imposed under this set of charges, no non-prescribed drugs, and no new law violations.
All right, and Ms. Capone, did you update his contact information?
I did, Your Honor, and for the record, he is held on those King County, for that King County warrant. I anticipate he'll probably be chained up there, so our pretrial date could maybe account for that.
I will do my best. Okay, then, Mr. Perez, you're released on this case while the case is pending. Don't violate the law, and I will give you a pretrial hearing date. That'll be on June 28th. June 28th at 8:30. And Mr. Perez, if it turns out that you're being held by King County on their charges there, just let this court know, let your attorney know, and then we can avoid issuing a warrant for you.
Okay.
Okay. Thank you, sir.
Thank you.
All right, Ms. Capone.
Your Honor, this is Mr. Erickson, number 3 on the calendar, and we're prepared to enter a change of plea today.
Mr. Erickson's here for a warrant return.
That's right.
Okay. So this document entitled plea of guilty statement is his?
That's correct, Your Honor.
Sorry about that. Laserfish was fighting me.
All right, so this is a plea to one count of ignition interlock. Looks like the state has agreed to dismiss the driving while suspended charge.
Yes, Your Honor.
Right.
And the agreement is just to plead with credit and close.
Credit for 3 days served is the recommendation. Okay. All right, Mr. Erickson, I've got your plea statement here now. Have you reviewed that with your attorney?
Yeah.
So by pleading guilty to the ignition interlock charge, you gave up your legal rights in this case. So you give up the right to go to trial, to have the prosecutor prove that charge beyond a reasonable doubt to a jury, the right to call witnesses to come to court and testify in your defense, the right to hear the witnesses who testify against you and question them. You're giving up the presumption of innocence and the right to appeal your conviction. Now, do you have any questions about those legal rights?
No, I don't.
Okay. All right. The maximum sentence for ignition interlock violation is 364 days in jail and a $5,000 fine. And you just heard me discussing with the attorneys, the recommendation is to give you credit for 3 days served and close the case. But you need to understand I'm not bound or required to follow the recommendation and could impose up to the maximum sentence. And did anybody make any threats or promises to you to get you to plead guilty to this charge?
No, sir.
The statement written on your plea form says on March 12th of 2021 in Thurston County, I operated a motor vehicle without an ignition interlock device when I was required to have one. Is that your statement?
Yes.
Okay, I will accept that guilty plea. And Mr. Fortunato, did you want to address the state's recommendation any further?
Your Honor, I would just say that obviously this is a over 3-year-old case. I will note Mr. Erickson is still suspended in 3rd degree according to his ADR and does still have an ignition interlock device restriction. However, understanding the age of this case, I do think this is an appropriate resolution. Hopefully, you can address some of the other matters that seem to be of similar charges. And I would ask the court to follow this agreed recommendation.
All right, Ms. Capone.
Your Honor, I'd similarly ask the court to follow the agreed recommendation. Ms. Simmons is the attorney of record, and it's my understanding that the parties kind of came to this agreement a while ago, and Mr. Erickson just didn't make it to court. And I would note that throughout the duration of his case, he actually made several attempts to quash warrants when they popped up. I'd also point out that the last time a charge was filed against him was back in April 2021. So he has been generally law-abiding. So I think this is a fair and appropriate resolution. With regard to any discretionary fines and fees, I'd like the court to take into consideration that he's currently not working. So whatever the court is willing to waive would be appreciated.
All right, Mr. Erickson, do you want to say anything before I sentence you?
No, just I do plan on getting this interlock put in. It's just a matter of coming up with the money here, and I'm just about ready to get it done. So another weekend we had that thing in, and we wouldn't be here right now.
All right, well, I think 3 days is probably enough jail time for not having your ignition interlock, and the case is 3 years old, so it's probably good use of everyone's time to just let you move on from this. So I will do that. Driving while suspended is dismissed pursuant to your agreement with the prosecutor, and your sentence for the ignition interlock is 3 days, no time suspended, credit for 3 days served. I'm going to waive the imposition of any fines and costs, and the case will just be closed.
Thank you, Your Honor.
And yeah, good luck to you, Mr. Erickson.
Thank you. I appreciate it.
And Your Honor, I thought there was maybe a tracking infraction along with that. I might have jumped the gun on that, but was there any action to be taken?
I'm not going to, I don't think I'm going to be able to address that off the cuff.
Understood.
It would have been, yeah, it would have been FTA'd a long time ago. All right, Ms. Capone.
Your Honor, this is Mr. Barstad, number 1 on the calendar.
All right, Mr. Barstad's here for a warrant hearing. Looks like he failed to appear at a compliance hearing. All right, so why did Mr. Barstad miss court?
Your Honor, he indicated that he did not get notice of court. I would point out, on June 23rd, the court did receive return mail, when trying to contact Mr. Barstead. He indicated to me that he was in good communication with his probation officer for a while, and then she went on, some form of leave. It seems like there was, some confusion over who he was supposed to check in with and when, because he was having regular communication with his probation officer over email, but then was told that he missed check-in with probation. The court was looking for proof of domestic violence treatment. Probation wanted him to have substance use treatment. He indicated that he did do a substance use evaluation and did a detox with Northwest Resources. He was told that he couldn't do DV treatment until he got into some type of substance use treatment. But those are the updates that I have with regard to the status of this case and his probation.
All right, Mr. Fortunato.
Your Honor, understanding that we're still waiting, it looks like I was just pulling up the plea of guilt here, and it looks like we still need like there's still DV treatment that needs to be submitted to court. I see an assessment, and I see some probation violation reports. So, Your Honor, with the age of this case and understanding that it looks like at one point a sanction was imposed by this court, it looks like on October 6th of 2022, I have a quote in here saying, if you skip out at future hearings, potentially the entire remainder of the 330 days imposed or suspended would be imposed. And understanding we're still waiting on some affirmatives that were a condition of Mr. Barstead being out of custody and completing this conditions of this sentence, I would ask for him to be held on $10,000 cash or bond, and understanding that potentially later we can address some of the other conditions that might need to be met, how we might actually get back re-involved in treatment, things like that, how we can ensure that he's going to be meeting the demands of this court. However, at this point, it does not appear that he is going to abide by the conditions if he is released. And I think understanding that we've had probation violations as recent as March of last year, where he wasn't showing up for treatment or wasn't reporting to probation, I think that that's an appropriate request, Your Honor.
Okay. Well, I have my doubts that Mr. Barstead's an appropriate candidate for probation. He's been reluctant, might be a generous way to put it, to comply with any of the conditions of his probation for well over a year now. So I'm not convinced that he should remain on probation. We have a lot of people who could benefit from the services of the probation department, and I don't want to take away from other people's ability to be successful on probation because Mr. Barstead's consuming more than his share of their resources. So we will take a final action on this, and if there isn't any kind of agreement on what that would be today, I'll set a hearing for that. In the meantime, we'll hold Mr. Barstead until that hearing.
And Your Honor, my request would be set.
I'm sorry?
My request would be for a hearing to be set.
Yeah. Okay. So Mr. Barstead through counsel just got done admitting that he did in fact violate probation, but he has explanations as to why he did so that may, I guess, mitigate the severity of that. But we'll set a sanction hearing within the next couple of weeks, and that'll be final action taken in his case. Okay. So Heather, what do we got? Yeah, he's going to be held for it. So yeah. 6th. Okay. All right, Thursday, June 6th at 1:30. All right, Mr. Barstead, we'll see you here then.
Mm-hmm.
All right, let's go over to Nisqually there. Sir, what's your name, please?
Michael Garrett Bennett.
One more time.
Michael Garrett Bennett.
Thank you.
Can you hear me?
Yes, Mr. Bennett, I do. Okay, Mr. Pazderka is your attorney, and you're here today for a pretrial hearing. I don't see Mr. Pazderka. Are you filling in for him, Ms. Capone?
Your Honor, I don't have any notes to go off of.
Okay.
I would guess that Mr. Pazderka's intention would be to ask the court to set dates going forward.
You had any contact from Mr. Pazderka? Mr. Fortunato?
I can check my notes, Your Honor. No, Your Honor. I would join in the defense's request to just
Okay.
engage.
All right, we'll get confirmation and trial dates set. Mr. Bennett, we'll get those dates set for your trial, and we'll send those over to you just as soon as the court clerk sets them. Probably a good idea to reach out to Mr. Pazderka.
Okay.
All right.
Well, there's no, they wouldn't offer some kind of plea.
I don't know. That's between Mr. Pezderka and the prosecutor. He would talk to you about that if there was one.
So how long do you think the next court date will be?
How long what?
Will the next court date be?
Well, it won't be too long. We've got to get a trial started for you within 60 days of your first court appearance on April 30th. So it's going to be relatively quickly, by the end of June.
All right.
All right. Thank you, Mr. Bennett. Okay, Ms. Capone, who have you got there?
Your Honor, this is Mr. Hayes, number 9 on the calendar.
And Mr. Hayes, good afternoon, sir.
Good.
All right, and Mr. Hayes is here for his pretrial hearing, and Mr. Kale is his attorney. Is anybody filling in for Mr. Kale?
I suppose I am, Your Honor, and my request would be similar, just to, because that date's going forward.
So his commencement date was on April 29th. So June 28th is his expiration. All right, so Mr. Hayes, we're going to get your case set for its next dates, which will be for trial on or before June 28th. We'll get you the exact dates shortly once the court clerk sets them. Same thing with this case, Heather. All right, so Mr. Hayes, you'll get that trial date sent to you shortly. But other than that, you're done for today.
Can I speak with you briefly?
Do you have a question?
Sir, my vehicle got stolen. While I've been in here, I need to go to Shelton to report it stolen. They took my bank card. I promise I'll go straight to Shelton. They're going to hold me there probably because I got a no bail warrant there.
Talk to Mr. Kale about that. And if he thinks it's appropriate, he can bring a bail request in front of the court.
So,
Okay, so Mr. Hayes, that's all for today. Okay, Ms. Capone.
Your Honor, present with me is Mr. Holmberg, number 10 on the calendar.
Ryan Holmberg. All right. And Mr. Holmberg, good afternoon.
Good.
And you're here today for a preliminary hearing on an allegation of domestic violence. All right, so Ms. Capone.
Your Honor, I met with Mr. Holmberg earlier, advised him of his rights, and I believe he understands them. Not contesting probable cause for today's purposes and asking the court to appoint counsel from my office going forward.
All right, Mr. Holmberg, I'll appoint the public defender's office to represent you. Okay, and what is the state's recommendation on conditions?
Your Honor, after reviewing the probable cause statement that was prepared by my office, I do think that and there's some substantial concerns. I'll admit Mr. Holmberg has no criminal history, certainly no relevant criminal history, but given what's alleged to have happened here, the state does and was prepared to come into today asking for $10,000 cash or bond, plus standard domestic violence conditions, additionally abiding by a no contact order that's been presented to the court. However, I'm certainly going to be allowing Erica to speak on behalf of the victim in this case. It's my understanding that she has some concerns over substance use, which was not alleged to have been involved in this incident. However, was mentioned, substance use issues were mentioned in the domestic violence packet that was presented and filled out by the victim in this case as an aggravating risk. or has been in the past. So with that, in lieu of the heightened bail, the state is amenable to scram and substance use restrictions in the alternative to that heightened $10,000 bail request. I would certainly also want to give Erica the chance to speak on behalf of the victim.
Okay, Erica, you have anything that Ms. Kemp would like the court to know?
Yes, good afternoon, Your Honor. I was able to get a statement from her today. If I read that for you. She said, "Hello, my name is Amanda Kemp, and until yesterday, I was the girlfriend of Ryan Holmberg. I have no intention of bashing him today. In fact, I want the court to know that I love this man and believe I have done all that I can to support him in the last 7 years while he's been under the constant control of his alcoholic mother, who threatens to ruin his life if he doesn't do what she says. He has been trying to quit alcohol while being an inherited alcoholic and my living with him, and his mother does not want me to. Outside of the incessant pressure of his mother, our relationship was good, but the constant threats of to fire him from taking care of his special needs brother and drinking in excess, had him at his wit's end for a long time. And because I love him, I hid what happened during the dark moments because I tried to understand and be supportive of his issues. But after yesterday, I can't do it anymore, and unfortunately, I'm scared that if he's released today with zero consequences and sent to his mother's house, he will go back to drinking and not taking care of himself. This especially concerns me as his special needs brother lives there and cannot defend himself or help if something goes wrong while Ryan's angry. Ryan needs help, and what he's doing for himself is not working. I don't believe he's in a good place to take care of his brother or anyone until he's better himself. At this time, I support the no contact order and have plans to leave our shared residence as soon as I physically can. I am injured and packing my child's things up alone, which could take a couple of weeks, which once I'm out of the house, I will contact the prosecutor's office. Thank you for acknowledging me today."
And Ms. Capone, your recommendation?
Your Honor, we'd ask that Mr. Holmberg be released on his own recognizance. He has no history, no warrants in history, and these are just merely allegations at this point. He is entitled to the presumption of innocence, the presumption of release. With regard to the no contact order, I'd be objecting to it because there is nothing in Mr. Holmberg's history. It's my understanding that Mr. Holmberg is the one on the lease. So I think a no contact order at this point would put the other individual out. Acknowledging that there might be some moving parts, we'd ask for a civil standby if the court is considering a no contact order, so that the other individual involved can potentially get out of the premises. With regard to any substance use conditions, I'd ask the court not to impose them at this time, given the fact that there was no allegations of substance use or alcohol involved here. Mr. Holmberg indicated to me that he is aware of the addiction that he's been struggling with. He is seeking medication for alcohol addiction, and he says that he's 2 weeks sober, which is not easy and I don't think should go without acknowledgement. He's also been working with Kaiser through telehealth to get some of these mental health issues under control. So Mr. Holmberg is working diligently to make sure that he's in a good place. I don't think he's a risk to others or the community. I think if the court is inclined to put a no contact order in place, that's sufficient to ease any concerns the court has. But Mr. Holmberg has never been involved in the criminal system before. And it's my understanding that he was actually the person who called the police, not Ms. Kemp. I have provided the court with good contact information for Mr. Holmberg. We'd ask for him to be released subject to the no contact order and ask the court not to put any alcohol or drug use conditions on Mr. Holmberg at this time.
I will release Mr. Holmberg. However, there'll be some conditions on his release. So, Mr. Holmberg, your conditions of release are going to be: don't violate the law, don't consume any alcohol, marijuana, or non-prescribed drugs, and don't possess any firearms or dangerous weapons. I will require you to have a scram, which you can have at county expense, to help you with the no consumption requirement, and then comply with the no contact order. That means no contact whatsoever with Ms. Kemp, except that you may go with a law enforcement escort to get your personal belongings to the address. Now, if Ms. Kemp does move away and she's not living there, you can live there, but as long as that's her residence, you can't go there, with the exception that I just mentioned. All right. You're to surrender any firearms, dangerous weapons, or concealed pistol license you may have to law enforcement immediately. Your next court date in this case is going to be on Wednesday, June 5th at 9 o'clock. All right, Mr. Holmberg, any questions about your conditions of release? All right, we'll see you back here June 5th. All right, Ms. Capone.
Sorry, Your Honor, this is Mr. Yarborough, also might be listed under Mr. Stanley, numbers 18 through 20 on the calendar.
And he is represented by Mr. Gasling.
That's right, Your Honor, I do have something to go off of.
All right, so we're here for pretrial, and we have a following probation issue.
So, Your Honor, we'd be asking the court to set dates for trial on the pretrial matter, have the FTC matter track, and at this time, we'd like the court to consider a reduction in bail based off change of circumstances.
Okay. When did you file a written request for a bail hearing?
Your Honor, if there's not one filed by Mr. Gasling, then I did not.
Okay. And those are due a day prior to the hearing so that everybody has notice? Right?
Yep. Sorry, Your Honor, I'm just covering for the.
All right. So if you want a bail hearing, file that according to Rule 3.7 and we'll have a bail hearing.
Understood.
Okay. All right. So Mr. Yarbrough, we're going to get your DUI case set for trial. The court clerk has not yet set a date for that, but they will, and you'll get notice of that shortly. Your commencement date was on April 29th, and the expiration of your time for trial is going to be June 28th. And the probation issue on your protection order probation, that will follow and be heard at the same time. And if Mr. Gasling files a request for a bail hearing and the appropriate documents and time frame, then we'll set that as well. All right, that will be all for today then, Mr. Yarbrough. It's not a phone call. Is Nathan Pierce here? Are you Mr. Pierce? Okay, yeah, just making sure that you're here. Yeah. And what about Joseph Woodland? Joseph Woodland? No. Oh, he's on Zoom. Okay, I got you, sir. Just making sure you're here. All right. So I think that's going to leave Jonathan Hand over there for you, Ms. Capone.
That sounds right, Your Honor. I don't have any reason to believe he's not coming, but I'll check in with jail staff.
All right, and Ms. Alt, are you going to be here for Mr. Woodland?
Yes, Your Honor.
Okay, why don't we call that case now then?
Thank you, Your Honor.
Okay, so yeah, we received a notice of appearance from Ms. Ganem, so that was kind of my guess there. All right, go ahead, Ms. Alt.
Your Honor, we are here for an arraignment. We will reform Marie and ask the court to enter a plea of not guilty. We'll stipulate the probable cause for setting conditions of release.
All right, Mr. Woodland will enter your not guilty plea to the charge of driving under the influence. And doesn't look like any bail was posted here. Okay, and then what's the state's position on release conditions?
Your Honor, there's no objection to a PR release. We're just going to be asking for the standard DUI conditions imposed by this court.
Okay, is that acceptable, Ms. Alt?
Yes.
All right, then, Mr. Woodland, you're released on your own recognizance. While the case is pending, don't violate the law. Don't go to bars or taverns. Don't consume alcohol, marijuana, or non-prescribed drugs. Don't drive unless you have a driver's license and insurance, and don't refuse a breath test. We'll get a pre-trial hearing date set for you. June 25th, Ms. Alt?
Let me double check that.
10 o'clock.
June 25th. That looks like that works. Is that room? What room is that in?
3.
Perfect. Okay, thank you very much.
All right, see you here then, Mr. Woodland. Thanks for coming in.
Thank you.
All right, and any update, Ms. Capone?
Your Honor, Mr. Hand should be on his way. I think the jail is just in the middle of count, so that's the accounting for the delay. But if Mr. Pierce is there, if I could provide a phone number, I could have him call me for an arraignment.
Okay.
Patty, I could probably get him a phone number again, unless you don't. Get it from Patty. Mr. Woylos, we actually reset your matter, or your matter's going to be reset. I don't know if you want to come up here.
Yeah,
you're to address that.
The court will send you notice for a new court date. Yeah. Did you make your Superior Court hearing?
Judge Office of Prosecutor over there. Let me out. Find it. The Superior matters district now.
Okay. Okay. Well, you've made your appearance here today as you're instructed, and we'll get a court date sent out to you. Okay, you're good to go, Mr. Whaley. Thank you. All right, and Mr. Pierce, we're going to we're going to give you Ms. Capone's number so you can call her and she'll consult with you before your court hearing, okay? So just stand by a second. Yeah, there's the number.
Oh, no, you're both present as well.
Ms. Kessling, would you mute your microphone until your case is called, please?
Yes, Your Honor.
All right, is this Mr. Hand?
It is, Your Honor, and I didn't have an opportunity to speak with Mr. Hand before court today. If the court wouldn't mind just giving me a moment.
Okay.
And Your Honor, I'm ready to proceed on Mr. Hand's matter.
All right, Mr. Hand, today you're here in court for your arraignment on charges of tampering with fire equipment and malicious mischief in the third degree. Ms. Capone?
Thank you, Your Honor. Mr. Hand and I reviewed his rights and I believe he understands them. I haven't received any report to base a probable cause position on, so I would just ask the court to enter a plea of not guilty and to appoint counsel for my office.
All right, enter a plea of not guilty to each charge. And was my question is Mr. Hand being held on these other matters that are pending hearing on June 14th?
It seems that way. Well, no, actually, he's not, Your Honor. What I'm seeing is that he's held by the Superior Court on $5,000. And it looks as though he might have been held on that for quite a while now because his arrest date is listed as May 12th.
I shouldn't be held on that if charges haven't been filed yet. I don't see a charge filed in that case. Oh, there's another one for 5/21 for today.
Looks like from my end, the charge is burglary in the second degree if that's not been filed.
Maybe maybe this hasn't been updated yet. I don't know. Right. Is the state going to be asking for release conditions?
Yes, Your Honor. So I'm prepared to establish probable cause on this matter.
Do you swear the testimony that you give in this matter will be the truth, the whole truth, and nothing but the truth?
I do, Your Honor.
Okay, it's the probable cause.
On May 20th, 2024, at approximately 9:20 p.m., Thurston County Sheriff's Office. Forgive me, it was Deputy Warnock. Deputy Warnock was dispatched to a malicious mischief incident which had occurred at 3491 Ferguson Street Southwest, which was Thurston County Jail in Thurston County, Washington. Corrections Sergeant Lund was calling to report an inmate, Jonathan Ham, for breaking a fire suppression sprinkler in his cell. Deputy Warnock responded to Thurston County Jail, while Sergeant Lund provided him with 4 corrections deputies' reports. After reading the reports, he had Sergeant Lund recount the incident. At approximately 7:55 that evening, jail's fire alarm sounded. Control indicated the fire suppression sprinkler in CD12, Jonathan's cell, had been broken. Corrections deputies responded to the cell to find water running out from underneath the cell door. Jonathan was standing at the window, soaking wet, with a blanket covering his head. Jonathan was the only occupant of the cell. As corrections deputies began to clean up the water, Jonathan placed the blanket under the door. This appeared to be in an attempt to back the water up and release it all at once to hinder the cleanup efforts of the corrections deputies. After pulling the blanket out, Jonathan was removed from the cell and searched. The sprinkler in the cell was broken, with the head having been damaged and removed. Later, a portion of the missing sprinkler head was found in a crevice at the bottom of the shower after Mr. Jonathan Hand had been showered.
Probable cause for both charges. What's the recommendation on release?
Your Honor, understanding that there are continued violations of the law that are reoccurring with Mr. Hand, conditions have been imposed on all of these cases to include no criminal law violations, and here we are on a third new law violation from this court, as well as several previous violations of the law at Superior Court. State does think it's appropriate to ask for $500 cash or bond on each case. Additionally, the state is going to be asking for all prior conditions to be imposed, which include no new law violations, as have been imposed by the DUI and then subsequently the vehicle prowl charges. Additionally, the state is going to be asking for a DCR evaluation. Understanding the nature of what's been charged here, I do think that's an appropriate request.
All right, Ms. Capone.
Your Honor, we'd be asking that Mr. Hand be released on these matters on his own recognizance. He's in custody, so he's not making any income, not receiving any government benefits, and the allegations here are non-violent in nature.
All right. Well, it certainly appears that it's another violation of release from the other earlier cases. Taking that into account, I'll set bail in the current case, but not impose any additional bail in the older cases. Other than that, don't violate the law. And the next date for hearing in this case will be June 14th at 9:30. And that's with his other cases that are already set for the same date and time. I think that finishes up the in custody part. And then did Mr. Pierce connect with you?
Yes, Your Honor. And just briefly, what was the bail amount imposed on Mr. Hand's matter?
$500.
I did speak with Mr. Pierce and I did advise him of his rights. And then he told me that he's represented by a private attorney So I'm not comfortable proceeding any further, but I will let the court know that I did my job rights.
Okay, so Mr. Pierce, you're hiring your own attorney for this case?
I am indeed, yes,
Okay,
Your Honor.
okay. Have you already hired your attorney?
Yeah, Jay Bernberg.
Jay Bernberg?
Yeah.
Okay.
Yep.
All right, let's make sure we have a good address for you. 205th Avenue East in Bonnie Lake.
Indeed, yes, sir.
Okay.
Yes, Your Honor.
I'm going to give you a new date for arraignment. Did Mr. Bernberg happen to say a date that he preferred?
He did not, but I can get in contact with him.
He will, yeah, he works with this court all the time, so
Yeah,
he knows. Okay. All right, you already posted bail, so you're released on that bail. You've made your court appearance. I'm going to release you to come back to court for your arraignment. Your conditions in the meantime: don't violate the law, no bars or taverns, no alcohol, marijuana, or drugs, don't refuse a breath test, don't drive without a license and insurance. And Heather, I previously found probable cause in this case with law enforcement's call. So we need an out of custody arraignment within 2 weeks. Okay. All right, 528 at 1:30. And since he's made his appearance, Mr. Bernberg can waive that appearance if he thinks it's appropriate. All right, I'm going to give you a written version of this to take with you, and you can also show it to Mr. Bernberg, and we'll see you here next week, and unless Mr. Bernberg tells you otherwise.
Yes, Your Honor.
Okay. The clerk will print that, let you know when it's ready, come up and grab it.
Okay, easy.
All right, and then Ms. Capone, are you doing the warrant hearings at 2:30?
I am, Your Honor, and I'm more than happy to meet with people or come over to the court if Your Honor wants me to. It's my understanding Mr. Fortunato may not have many objections to quashing, so it's the court's call as to how you want me to.
Okay, well, there are definitely people here, but yeah, it's entirely up to you. If it's easier to come over here, I can wait.
If Your Honor doesn't mind, I'll come over so that way I can hand out contact information.
Sure.
Okay,
All right, sounds good.
About 10 minutes.
Okay, and Ms. Rowe, in the meantime, we can take your case.
Okay, Your Honor, I am present for and with Miss Archer.
Okay, and is that Miss Archer there is the Samsung?
Yes.
Okay, all right, looks like Miss Archer had a confirmation hearing, and that's what she missed back on the 3rd. Any objection to releasing her with a new court date, Mr. Fortunato?
No, Your Honor.
Okay, and then Ms. Rowe, do you have up-to-date contact information for Miss Archer?
I do, Your Honor, and she is in good contact with me.
Excellent. Okay, I'll get her on the calendar for a pre-trial hearing, so just stand by a second. The warrant will be quashed, and then just clear back on regular pre-trial.
Miss Archer might want to update her number with the court, or has that already been done, Miss Archer?
I believe I just gave it to the lady I talked to at the desk that answered the phone.
Yeah,
I'm not sure if she recorded it.
They usually get that. So does the number end in 8223?
Yes, sir.
Okay, then we've got it. All right, Ms. Archer, your next court date will be July 3rd at 9 o'clock. We'll send out reminders as well.
Okay.
All right, and you're good to go, ma'am. The warrant's quashed.
Thank you. Okay, thank you.
You're welcome. Okay, and then for the rest of you folks who are here for warrant hearings, whether you're on the Zoom call or in the courtroom, Ms. Capone from the Public Defender's Office will be here in just a couple minutes to help you out. All right, so we'll be at recess till she's here. Question?
Should I no contact order at 145 hearing?
You should be in courtroom 3.
Oh, it said
Just-
2 on there.
Yeah, it might have been a misprint. Right across the hallway in courtroom 3.
Right, where's the recess?